Good evening. Welcome to Left, Right and Centre. In a huge setback to the opposition, the Supreme Court has refused to consider a petition by 14 opposition parties that have accused Prime Minister Narendra Modi's government of abusing its power and using central investigating agencies to harass and intimidate its political rivals. The petition filed by senior advocate Abhishek Singhvi on behalf of the opposition parties claimed that there was a drastic and exponential increase in the number of cases registered by the Enforcement Directorate and the Central Bureau of Investigation against opposition leaders since 2014. So that's going to be our first debate. In a few moments from now, I'll be joined by the senior lawyer Mukul Rohatgi, who's got a view on these developments in court. Was this petition by opposition leaders at all tenable? Later on the show, and it's a half-an-hour program today because at 1:30 we've got a very special interview with Ghulam Nabi Azad done by my colleague Sanket Upadhyay. But in this half an hour, a media outlet cannot be muzzled just because it criticizes the government, is what the Supreme Court has said, as it lifted curbs on a Malayalam news channel ordered by the centre to shut down on national security grounds. The court said that the channel media wants criticism of government policies and actions cannot be construed as being anti-national or anti-establishment, and that an independent press is essential for a vibrant democracy. Well, joining us now for his view on this, the senior Supreme Court lawyer, Mr. Mukul Rohatgi. Thanks so very much for being with us. At one level, what the Supreme Court, what the Chief Justice said, makes sense in that all citizens in this country are equal, right? And therefore, the political class are not special. So if justice is being sought, it needs to be applied for everyone. So therefore, if the argument is to be made that the agencies are being unfairly used, the Supreme Court seemed to suggest that it's not enough to say that political leaders are being solely targeted. If it is, an effort to seek justice, then the petition needs to apply to everyone. Is that correct, sir?
Yes, that's what I've heard in regard to some oral observations made by the court. But Vishnu, I would like to approach it in a slightly different manner. One is the legal aspect of this petition, and the other is the non-legal aspect of this petition. As far as the legal aspect is concerned, this petition was doomed from the beginning. It is misconceived because political parties by themselves do not have fundamental rights. You have to have a fundamental right to approach the Supreme Court under Article 32 of the Constitution. And fundamental rights are available to individuals. They are not available to companies, they are not available to partnerships, they are not available to political parties. That is one. And two, the second legal ground on which it was doomed was, if you were to look at the prayers, the prayers are rather amorphous. You lay down guidelines as to the nature of arrests, nature of bails, see what is happening in the country. These are all general kind of stuff which is not relevant in a court. There are already guidelines on bail by umpteen judgments.
Right.
Guidelines on the manner of arrest by umpteen judgments. So there is nothing new. You can't reinvent the wheel. So there was no real substance in the petition on the legal plane.
Right.
But if you come to a non-legal plane on the issue that you were mentioning, look, it seems to be a political battle between the ruling party and the grievance of the opposition parties. Now, this political battle has to be fought outside the courtroom. You have to fight it in parliament, you have to fight it in legislative assemblies, you have to fight it in public debates, you may have to fight it in a demonstration in roads, in parks, whatever. That's what you have to do. So, you can't go to court and say, oh, look, we are being victimized. I mean, you have to then make out specific cases. Specific individuals must go to the court, seek relief for themselves. Somebody can go to court and say, look, I am being victimized because I am a member of an opposition party. See what is happening to me. These are my facts. Compare these facts with somebody else, etc. But this kind of general stuff, I mean, according to me,
Sir, I take your
completely
point,
misconceived.
but let me ask you this. If political parties on the basis of facts, in other words, the rate of prosecution from 2014 onwards directed against opposition parties is much more, several times more than what, say, the government and the agencies target, members of the BJP itself. Now, they say that the agencies are being misused. We want justice over here, right? So I understand the legal argument you're making, but you also said, sir, that there are political forums and there are other forums available. But they aren't seeming to get the justice they seek over there.
No, but please tell me one thing. Please tell me one thing.
How does this move?
By making this kind of an attractive, first blush attractive kind of a submission, what do you expect the court to do? So should the court say that all opposition leaders of whichever party or whichever hue they may belong to, in whichever jail they are, in whichever case they are, without any specifics, because every case is specific in a court with specific facts. So you want a general omnibus observation that whoever is wherever belonging, wearing a badge on his shoulder that he is an opponent in a political party of an opposition party, he should get bail or he should get relief. Is such a thing possible? I mean, what is possible is an individual goes to court or a representative of somebody who can't go to court goes to court. That's what there is a PIL. PIL is for what? Basically, Bandhua Mukti Morcha. Poor people could not go to court, so somebody went to court for them.
Right.
That kind of stuff. But here, can you have this kind of an amorphous relief?
No, but
that is why those reliefs Vishnu were not even prayed for.
No, I understand. I understand what you're saying.
Lay down these general guidelines. The courts have no time to lay down all this general stuff for nothing.
Got it, sir. But again, the counter argument to that, which I presume the opposition leaders would say, is that look at the rate of conviction among all of these cases which have been filed since 2014. It is negligible, and that is also an example of how agencies are being misused. Therefore, we seek justice.
As I told you,
so where will they get justice, sir?
It has to be case specific. On the same analogy, if the conviction rate in the country by and large is 30% or 40% or whatever, can people who are otherwise being convicted or incarcerated, can they say that your conviction rate is so poor? So what's the point of keeping some in jail and some not in jail? Let everybody go. It doesn't work like that. There is no negative equality. Okay. There is positive equality, no negative equality. It's like one thief saying you can't catch everybody else, other thieves, so let me also go. So it doesn't work like that. I mean,
so one final question, sir. One final question. And the question is this. How would you respond to the opposition leaders or anybody for that matter who says that, look, on the basis of what the Supreme Court has done today, there is a carte blanche on the government / the agencies to go after the opposition any which way they want?
No, but Vishnu, as I said, it has to be case specific. Individuals, why can't these individuals whose cases are being touted by these opposition parties, why can't they actually go to a particular court, whether High Court, Supreme Court or any court, and say, look, this is what's happening to me. It can't be, as a general, as I told you, it cannot be on a general plane at all.
No, I take your point, sir, that legally perhaps this was untenable, but I think the justice that opposition leaders were looking for, it isn't going to be delivered in the courts now, not in this format. Where will they get it is the question. Bye. I think that's what I was sort of getting at. Thanks, sir. Thanks very much. Wonderful to speak to you. Well, joining us now, Ghanshyam Tiwari of the Samajwadi Party, also joining us now, Shazia Ilmi of the BJP. Thank you both very much for being with us. Ghanshyam, would you say that your legal challenge, the way it was framed, besides anything else, was wrong, was dubious? How did you expect the court to make an omnibus ruling?
Well, good evening, Vishnu, to you, Shazia, and the viewers. I believe that more than the legal challenge, the foundation of the presentation was also the statistics behind this. Mm-hmm. And it is a good step by the political parties to come together and present the statistics both to the court and to the people of the country. It is another thing that legally the court did not find this to be tenable, and it could lead to discussion whether politicians enjoy a special right or not. But a government that has gone on to target political parties who has been accused for this by chief ministers who are current chief ministers, by members of parliament, by journalists, by civil society, that such a government is called out on every forum, whether we succeed or not, is a good step in democracy.
Shazia, the point opposition leaders would make is that this persecution will continue.
Well, I think we just had Mr. Rohati explaining in great detail as to how the bench reacted to this plea, and how the joint plea by 14 parties was not entertained and was in fact junked. I think there is a lesson to be learned here. The lesson being that the rule of law prevails. The law is the same for everybody. There cannot be some sort of a class action and political class, or the opposition seeing themselves as member of a certain group, seek some kind of judicial recourse only because they're members of the opposition. For instance, you see Misuse Sisodia. He did move a high court in fact against the order of the lower court today, only to ask for bail for himself, which was refused later. But he had to move individually. So, and this is exactly what the court made amply clear and unambiguously, that if you can come up with specifics, statistics cannot be extrapolated to have a new kind of a guideline only for the political class, and of course the subsection of it being the opposition.
Okay.
That itself was found as a proposition extremely dangerous, one, and absolutely untenable.
All right. Ghanshyam, what is the opposition strategy going to be?
Well, political class is a voice of the people of the country. So is media. We are on NDTV. Wasn't NDTV raided by the same government? Aren't other media channels who have reported against the government, reported facts against the government, not in a shrieking rhetorical propagandist voice, but in plain voice? They have been raided. So it is important that political parties, as the most vibrant voice in democracy, continue to approach every forum, whether it is parliament. By the way, parliament is shut because the Prime Minister is scared about answering to the unfolding Adani scandal, or whether it is media channels which are in any case by this government harassed or raided, or it is the public's court which is on the street, that the opposition raises the voice. And every time it is the opposition parties raise this voice, expose this government on the basis of facts, not on the basis of fiction. Every time we expose this government, we also strengthen the voice of those in civil society who are harassed by this government, put in jail for no reason, or we strengthen the voice of media that is in the business of reporting truth rather than in the business of supporting this government on false matters. And we strengthen the voice of everyone who believes that citizens must have the right to question the government. So the strategy of opposition is to no matter what a setback is, to go back to every forum and report the facts that here is a government that is using CBI, ED. For example, this government did a midnight raid at CBI. Why is it so important for this government to control CBI? For example, this government went against the court guidance on ED. Why is it so important for this government to have a person at the helm of ED whose tenure has ended? Because these have become instruments by this government for muzzling the voice of democracy.
And Shazia, do reply to that, but I'll ask you one question.
Yeah, I will. Yeah,
parties argue that 95% of political leaders.
I've done a lot of work on this subject.
Half a sec. Shazia, can I just finish asking? Parties argue that 95% of political leaders facing ED CBI cases are from the opposition.
Yeah, this is an argument that has been made for the longest period, for the last 1 month. The fact of the matter is, many of these cases started during the UPA's time. If you were to look at Lalu Prasad Yadav's case, if you were to look at Mulayam Singh Yadav, I mean the party of my good friend Ghanshyam's here, you will realize that these cases have been there for the longest period. It's only now that the opposition decides to use this as a binding glue to get them into some kind of unity to speak against the ruling party, only because they cannot be electorally defeated any other way. So this doesn't really cut any ice, and convictions also happen after investigation. Unless and until there is no investigation, convictions can't happen. But this is exactly the point the Chief Justice Chandrachud of all the people said that top court cannot lay down abstract guidelines. Come back with me with one or more cases where there has been a specific instance or instances of the agencies being used to selectively target leaders. On the basis of the law that we have laid down, we can evolve general principles, we cannot with regard to facts of the case. So the fact of the matter is that somebody like, I gave the example of Manish Sisodia, he would have to answer as to why, there is a link between all those, and there is a money trail, and there's a link with, for instance, KCR's daughter, K. Kavita, Dinesh Arora, and whatever. I'm giving you examples of the case. There'll have to be, Tejasvi Yadav will have to go specifically and give answers as to why there is, for real, there is a plot for land, for job scam. So these are all individuals. So
no, but Shazia, I think the point,
you realize that
sure,
it's all opposition. But also being in the opposition does not mean that you can get away with corruption.
No, that's fine. You made that point. But let me ask you this, Shazia. The argument is that the process is the punishment, right? And that given the low conviction rate, the allegation is that, look, you're just out to, you as in the agencies are just out to get opposition leaders, knowing fully well that they won't be convicted.
Well, that is not true. I want to just read out the figures of what happened in the prevention of money laundering case, and that's huge. If you look at the numbers and how the government has been working, you will realize in the past 9 years, properties worth 1,10,000 crores were seized under PMLA. So that's, we're looking at a huge this thing. And if the agencies are going allowed to work independently, and their job is to expose graft and find evidence against those who have been engaging in this, that is a job the agencies will do. Just because all the members of the opposition have found common cause with this and are being also investigated, it cannot be used as an example or as a point to denote that there is persecution against them. There is evidence. That's why. I mean, the fact of the matter is that Sonia Gandhi and Rahul Gandhi are out on bail. Their 5 lakhs did become 800 crores. So there is evidence to that, which is why the court took action, which is why bail was given later to them, which is why they were charge sheeted.
Okay.
So you have to look at the evidence.
You have to look at the substantive part of the cases. Ghanshyam, would you like to reply to that? The bottom line is that, there are cases over here, and it's not right to just sort of say that all of them are fake cases. There are really substantive cases as well. So at the end of the day, you're just going to have to fight it out one by one if you feel it's unfair.
Well, the overconfidence of arrogance is visible often in BJP MPs. For example, the Sangli member of parliament from BJP announced on a podium that I am not worried about ED because I belong to BJP. Another legislator who switched to, and while media reported on it, it's a fact. Another legislator who switched from Congress to BJP said, now I can sleep easy because CBI and ED will not come after me. So again, pronouncements after pronouncement from BJP leaders alone. This is a party that brought an infamy to India for the first time in 70 years, that there are from a single party over 100 members of parliament with criminal charges. In Uttar Pradesh, they have over 100 MLAs with criminal charges, this single party. So I believe that the data speaks for itself, that one can criticize the opposition, that the framing was right, not proper, and BJP can celebrate that the court went against the point made by opposition. Mm-hmm. But in reality, every such step by opposition coming together, saying that parliament must function, going to the court and saying that voices in democracy cannot be muzzled by CBI and ED, who have become instruments of this government, in fracturing elected governments in states, in enabling the horse trading that is often trademark of BJP, in enabling every misuse of democratic power that this government has. The challenge is that they are setting a precedent. They are setting a precedent that future governments will use and brazenly use in the worst format against the citizen and subsequent opposition parties. And BJP will find itself in opposition, but by that time it will be too late for the Indian democracy.
Well, let's see, this will all ultimately come back to court. I'd like to thank you both very much for joining us and sharing your thoughts on this. It's a huge loss for the opposition today, a huge victory, some would suggest, for the BJP, which has been fighting against this entire issue, saying that no, if there are allegations of corruption, you need to fight it out legally. That's what the Supreme Court seems to have said as well. Media outlet cannot be muzzled just because it criticizes the government, is what the Supreme Court said today as it lifted curbs on a Malayalam news channel ordered by the centre to be shut by the centre on national security grounds or being denied their license. The court said that the channel media wants criticism of the government's policies and actions cannot be construed as anti-national or anti-establishment, and that an independent press is essentially for a vibrant democracy. Scrapping an order by the Ministry of Information and Broadcasting that the channel refused to renew the government refused to renew the channel's broadcast license for want of security clearance. The Supreme Court pulled up the Home Ministry for raising national security claims out of thin air. National security cannot be raised to deny people their rights. It was raised by the Home Ministry in a cavalier manner in this case, is what Chief Justice D.Y. Chandrachud actually had to say. So that's an important development. Yes, sir, thank you very much for being with us. This is a landmark judgment, not just in terms of your company, but also I think in terms of press freedoms, because I think I would argue that perhaps the most important aspect of this is, and I quote, the critical views of the media on policies of the government cannot be termed anti-establishment. If truth to power is the basis of journalism, then the Supreme Court seems to be reinforcing what we all believe in.
Thank you for inviting me to your show, Vishnu. The first point is that, as you said rightly, this judgment is not just a win for Media One only. This is a landmark judgment, as you said, and this makes it very clear that freedom of the press cannot be taken for granted. This was very clear to anyone in this country, except for those in their power. I should say that. And what this judgment does, in fact, is that to correct them, correct those in the power, I will say. So secondly, criticizing, as you said earlier, criticizing the government on merit is not an anti-national activity at all. Not that it is. That should be the way an independent media should function. Actually, the Supreme Court has made it very clear that should be the way maybe an independent media organization should function. We were accused of criticizing the government on on issues like CAA, NRC, and the misuse of UAPA, etc., etc. These criticism cannot be judged as anti-national activity. That is the major highlight of this judgment. And another fact is that national security rhetoric cannot be used, cannot be considered as an excuse to ban a media organization at all. If there is a real national security concern, what should the government do is that they should come up with the right reasons for that. Maybe justify.
But Mr. Raman, let me just jump in over here because the point you mentioned, and we know this is a fact, that in the past. It's true across fora, it's true in Parliament, it's true as far as dealing with the media is concerned, and it's not just this government, even in the past. National security, those two words give the government some sort of magic power to deny information, right? Or to label people or to stereotype people, and then it sort of adds up to, they violate national security, hence they are anti-national. Today also what the Supreme Court said is this entire business of handing over arguments in sealed envelopes is deeply problematic. In the past, on national security grounds, this has been done. So what did the Supreme Court actually talk about that, saying that the sealed envelope business is problematic? How significant is that?
The point is that on the pretext of national security, the government does not reveal the reasons for the ban on Media One, and the Supreme Court considers this action as a denial of natural justice. There is the point. actually Supreme Court reminds the government of that to make to give the idea or give the information to the other party also is a basic, that is to the heart of our constitution, to the heart of our legal practice. So the Supreme Court has reminded this to the government. So this issue of sealed cover has been there on discussion for a time now. I think you remember it. You can also remember this one. But only now the Supreme Court has ultimately closed the issue. Right. Actually, even though on earlier occasions the Supreme Court had expressed its displeasure over it, this is the first time that this Supreme Court.
And sir, I found, Mr. Raman, two words that the Supreme Court used particularly significant when they said that the Home Ministry was raising national security claims out of thin air. In other words, it seemed to be manufactured. I think that's again key. I mean, the entire argument on national security, the Supreme Court seemed to suggest, was utterly baseless.
Vishnu, ours is the channel, maybe one of the few channels in the country that has come clean out of a rigorous judicial review. Now, we have been examined right from A to Z on our functioning, our ownership, our content, and as well as anything. So we have come up. I would say in the country, NDTV was the first major channel to go through such a audit. But now Media One has also won this audit, this judicial audit, I will say, and judicial
trial
review.
By fire, right, Mr. Raman? You won that trial by fire today.
Yeah.
Look, thank you very much for being with us. It is, as I mentioned, a landmark day not just for your company and your right to do journalism, but I think it's a red letter day for journalists across the country and the freedom of the press, which is essentially what that lovely book of ours called the Constitution talks about. We leave it over there, take a short break, more coming up.